Good afternoon, sir. Before we do anything further, I want to advise you of your constitutional rights. You have the right to remain silent concerning these charges. Any statements you make could potentially be used against you in court. You have the right to plead not guilty to any charge and let the trial in front of a judge or a jury. You have the right to stop answering questions at any time if you're interrogated, to have an attorney present with you during questioning. You have the right to a public and a speedy trial. At the trial, they can cross-examine the witnesses against you, summon witnesses by way of subpoena, testify on your own behalf, and offer any defense on your behalf. In any criminal trial, it's the state's burden to prove you guilty beyond all reasonable doubt. You are entitled to be represented by counsel. I know you have counsel here today to make a bond argument on your behalf. As a person held in custody, you are entitled to reasonable bail set by the court. If you're not an American citizen, you should understand that conviction for these offenses could carry the possibility of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. If you have any questions about your constitutional rights, please bring them up at this time to speak with counsel. I know you are a member of the bar, so do you understand your constitutional rights?
I do, sir.
All right, thank you. Bail Commissioner?
Good afternoon.
Yes, good afternoon.
The defendant is
I believe the bond is set by the court at $2 million is appropriate. If the defendant makes that bond, I'd ask the GPS be a condition of his release with house arrest, only leaving for things the court deems appropriate. While you could argue that the other two co-defendants cooperated with the state police when they were trying to serve these warrants that started out being secret but somehow got out and people knew about it. So Mr. Mawhinney, knowing about this warrant, did evade the state police for a substantial period of time yesterday. He was actually found up by the Mass border. We knew that he was at his lawyer's office. We went there. Didn't find him there. He apparently just left, but they didn't know where he was going. So we had to use technology to find him. So it's not a situation where he cooperated knowing this warrant was there, since it was all over the news before we got there. So I believe the $2 million is set by the court with those conditions I requested as appropriate.
Thank you. Counsel.
Thank you, Your Honor. I'm requesting the court set a $500,000 bond, keeping in mind all of the conditions that I'm sure that the court is going to impose for a number of reasons. And first, we start with the facts that are typical in an argument like this. He's a lifelong resident of the state, as the bail commissioner indicated. He's a coach for a number of years, and he's been well established in that community. He has substantial ties to the state. And then we add the fact of his law practice. He's a sole practitioner. He's been doing immigration law for the past 20 years and been practicing as an attorney in good standing for the past 30. Never convicted of any crimes. He does have pending cases in Hartford. We represent him there. He has made every single court appearance. He has turned himself in when he needed to. And there's never been any issues there. I also have some concerns. I don't believe that Mr. Mawhinney has the financial resources that perhaps, without knowing more, that some of his co-defendants may have. Obviously, these cases has taken a hit on his practice. And so I think that financial amount with the conditions that I think the court is going to impose would do that. And also, very briefly, you look at the warrant. I struggle to find the case that the state will eventually prove here to show an agreement, to show a conspiracy. And I don't think it's a strong case against Mr. Mawhinney. And for those reasons, Your Honor, I do request that bond, keeping in mind, again, he's a sole practitioner who will hopefully be able to continue to service his clients in the courthouses throughout the state while the case is pending and earn a living. Thank you.
Is it true that one of your client's pending charges involves a violation of a court order?
It does, Your Honor. It involves violation of a protective order.
Well, in light of that, in light of the gravity of the offensive charge, I'm going to leave the bond is set at $2 million with the condition, if that bond is posted, of IPS and GPS house arrest, Do not leave the state of Connecticut without permission, surrender any passport. The exceptions to the house arrest would be medical appointments, church services, and meetings with counsel in defense of these charges. That is the court's finding. What date?
Transfer to Part A, Your Honor, for February 20th.
Your Honor, if I may, any issues regarding going to work, that was not in the court's.
The defense, and your indication that your client may not be able to post that bond, I was assuming that would not be an issue. The court set the bond. The nature of a bond is to ensure an appearance in court, and the amount of the bond must also match the gravity of the defense charge. And so I think the bond is appropriate of $2 million. So that is the court's order.
Thank you.
February 20th for further proceedings.
Thank you.
Thank you, Your
So
Honor.
you need to take steps to hire counsel. They're only here today to argue your bond. If you cannot afford an attorney, I will consider an application for a public defender, but we're going to do that on a case-by-case basis with an accurate financial affidavit.
Your Honor,
February 20th.
220 in Part A, please.
So ordered.
Thank you. Next matter, Your Honor, is on line 8 on the arraignment docket, Michelle Traconis.